Welcome back to The Explainer. Today, we're unpacking a genuinely fascinating landmark ruling from the South African Constitutional Court. It's a case that forces us to grapple with the incredibly complex intersection of commercial sex, gender discrimination, and the precise limits of constitutional law. The case is known as S versus Jordan. And let me tell you, the questions it raises about equality and morality are just as relevant today as they were the moment this judgment was handed down. Okay, let's dive into this. Here is our roadmap for today. We'll start with the constitutional challenge, move into the sex worker question, explore the dissenting view, look at the brothel consensus, and wrap up with the final verdict. Before we even get into the facts, I want you to keep this central conflict in mind. Think about it. Is a law fundamentally unconstitutional if it explicitly punishes the person selling the sex, but doesn't explicitly punish the person buying it? This right here is the core philosophical and legal dilemma of the entire case, and it literally split the highest court in the land.
Let's start with Part 1, the constitutional challenge.
Our story starts back in August 1996, and it played out kind of like a scene from a crime thriller. An undercover police officer walks into a brothel in Pretoria. He pays 250 rand to an employee for a, quote, pelvic massage from a sex worker. Well, this sting operation led to the arrest of 3 women: Ellen Jordan, the brothel owner, Louisa Broderick, the manager, and Christine Jacobs, the sex worker. Now, during their trial, they openly admitted to the acts, but instead of just taking the hit, they launched a massive legal counterattack. They argued that the specific provisions of the Sexual Offences Act used to charge them were fundamentally unconstitutional and violated their basic human rights.
And this brilliantly illustrates just how old-fashioned the legal framework was at the time. To understand what they were actually charged with, you have to look at how the Sexual Offences Act defined unlawful carnal intercourse. The law quite literally defined it as any intercourse outside of a heterosexual marriage. Crazy, right? This incredibly broad, morally charged terminology from the past served as the legal baseline that these 3 women were fighting against under South Africa's new progressive constitution. Moving right along to Part 2, the sex worker question. So, the provision under the microscope here is Section 211A of the Sexual Offences Act. This text makes it a criminal offense for anyone to have unlawful carnal intercourse for a reward. But pay close attention to the phrasing. It explicitly targets the person receiving the reward, meaning the sex worker. What it deliberately leaves out is the person paying the reward, the client. Naturally, the appellants argue that this lopsided legal targeting amounted to unfair discrimination.
The Constitutional Court had to figure out if this was true discrimination. Judge Nkobo, writing for the majority, looked at this from a very pragmatic, almost economic perspective. He argued that the state absolutely has a right to outlaw commercial sex, and, well, if you want to outlaw a market, you target the supplier. As he put it, drawing a line between the dealer and the customer is actually a very standard legal practice that you find in plenty of other laws, like those regulating liquor or prescription medicines. So the crucial point is how Judge Nkobo built his legal rationale. First off, he noted the law is technically gender neutral. It applies to both male and female sex workers. Second, by targeting the merchant, the state is really just trying to cut off the supply of commercial sex at the source. Third, the customer doesn't actually get off scot-free. Under common law and the Riotous Assemblies Act, the customer can still be prosecuted as an accomplice. And finally, and this touches on a much deeper societal theme, Nkobo argued that the harsh social stigma sex workers face comes from societal attitudes, not from the actual text of the law itself. Which brings us to Part 3, the dissenting view. Here is where you see a really deep philosophical divide. On one side, you've got Judge Nkobo treating the law as a gender-neutral economic regulation aimed at merchants. But on the exact opposite side, Judges O'Regan and Sachs looked at the very same law and saw indirect gender discrimination. They essentially said, you can't just look at the law in a vacuum. You have to look at its real-world impact, which overwhelmingly falls on women and perpetuates some pretty heavy patriarchal double standards.
Now, what's really interesting about this slide is this incredibly powerful quote from the dissent. She is visible and denounced. He is faceless, a mere ingredient in her offense. O'Regan and Sachs completely rejected the idea that the stigma is just some societal issue that's separate from the law. They argued that the law itself creates and reinforces this stigma by making the woman the primary criminal, while the male client, if he's even charged at all, is just a background accomplice who can quietly return to respectability.
For the dissenting judges, making the sex worker the primary offender, while the client is merely an accomplice, is a direct violation of the constitutional right to equality.
They argued this legal structure actively entrenches deep patterns of gender inequality. By legally holding women to one standard of conduct and men to another, they concluded that the law constituted unfair, indirect gender discrimination, which should make it unconstitutional.
Okay, let's look at Part 4, the brothel consensus. Let's move to and see how this builds. Because despite that fierce debate over the rights of the individual selling sex, the Constitutional Court was completely unanimous when it came to running a brothel. Every single judge agreed that the state has a perfectly justifiable right to regulate, limit, and outright ban the broader commercial exploitation of sex. They looked at the legislative facts and the state's justifications for stepping in. The state argued that the business of commercial sex is often tied to severe social ills. We're talking violence, international human trafficking, child prostitution, and drug abuse. And while the appellants argued that decriminalization might actually help solve those issues, the court unanimously agreed that the state's goal of combating these specific harms was a highly legitimate constitutional purpose.
This quote from the judgment captures that consensus perfectly. The right to free economic activity is an absolute. In a democratic society, the state is absolutely allowed to limit economic activity if those measures are designed to promote social justice, protect human development, and improve the quality of life. For all the judges, regulating and criminalizing brothels passed this test with flying colors.
And that leads us to Part 5, the final verdict. So here is how it all shook out in the end. Neutrally speaking, the court ruled that the rights to economic activity and privacy were not unconstitutionally violated by these laws, noting that the privacy of commercial sex is heavily diminished compared to private intimacy. The provisions against keeping a brothel were upheld as completely valid. And crucially, because Judge Nkobo's view held the majority, Section 21AA, that law targeting the sex worker, was declared constitutional. Because the laws were ultimately upheld, the original convictions of those 3 women from the Pretoria brothel were fully reinstated. But perhaps the most fascinating takeaway from this explainer is the court's view of its own power. The judges stated very clearly, courts are concerned with legality, not desirability. Whether South Africa should criminalize, heavily regulate, or totally ignore prostitution is a massive policy choice. And the court ruled that in a democracy, that complex choice belongs to the elected legislature, the parliament, not to unelected judges. Which leaves us with a pretty profound dilemma to ponder. Should the law be a tool to enforce a society's baseline morality, or must the law be actively reformed by our legislatures to ensure it protects vulnerable people from the very stigma that society creates? It's a massive question about the role of law in our everyday lives. Keep asking these big questions about justice, and we'll see you in the next one.